Great. Thank you so much, everyone. Welcome to this event on multi-stakeholder action through corporate climate litigation and intergenerational climate justice. Thank you all for being here. I know that with everything happening with the global stocktake text, people's minds may be elsewhere, but we really appreciate you being here to discuss the multiple tools that we have to work for climate justice. So my name is Alexis Mcgivern. I'm a researcher at the University of Oxford, and I'll be moderating this panel today along with some brilliant colleagues. So we're excited for the next 90 minutes of your time to get into some of the different tools that we have from scientists, from legal scholars, lawyers, young activists, and NGOs to make sure that we are holding strong climate accountability. So we have a really great panel today that spreads a massive group of stakeholder groups. We have Maria Sujkowska, who's joining us online, who is the head of area. Oh?
Is she?
Yes, she is, yeah. Who is the head of area at Corporación Norte Grande in Chile, and is also the global focal point at the children and youth group at LAC, the civil society mechanism of MGCY. We have Genaro Matias Godoy Gonzalez, who is a youth activist from Chile. He is the current focal point for the Finance and Markets Working Group of Youngo, and is also a Global Youth Coalition champion and one of my dear colleagues. We have Dr. Delta Murner, who is the lead scientist for the Science Hub for Climate Litigation at the Union of Concerned Scientists. We have Lea Main-Klingst, who is a lawyer at Client Earth and works across programs on international issues, and will be speaking to us about some of the advisory opinion work that Client Earth is doing. And then finally, we have Dr. Ivano Alogna, who is research leader in environment and climate change law at BIICL, which is the British Institute of International Comparative Law. So this session is really about how different stakeholders can use all levers in their toolbox, and we'll be hearing from Ivano later about the toolbox that they're working on, but the broader toolbox for strong accountability for climate damages. We will hear from speakers that are representing academia, youth organizations, scientists and lawyers and legal scholars to understand how these cogs can work together for a strong accountability landscape and litigation, both for states and for corporates. So with that, we'll begin with a youth testimony from Genaro to acknowledge the important role that youth activists play in climate accountability. Oh, over to you, Jen.
Well, thank you so much for the opportunity of having as youth giving the opening remarks and this day. And let me say that this is not an easy day for anyone here. So dear colleague, friends, concerned tribe that is defending the life in our planet Earth. As we sit in this room, after reading the draft text of the global stocktake that just came out, it's clear that economic interests are most of the time over the life of this planet and life of people. The best available science is called the 9 times, and the urgency to accelerate action and scale up support and build the integration of solutions for resilient food system, nature-based solutions, conserving and restoring nature and ecosystem, all for adaptation measures that can mitigate the damage. These are beautiful words said on the global stocktake, but it's clear that science is not being reflected as an ambition of the text of the actual root of the problem of our fossil fuel addicted economy, and then talks about efforts, in enhancing towards substitution of unabated fossil fuel in energy systems, the reduction of production and consumption of fossil fuels only when we're talking about inefficient fossil fuel subsidies that encourage wasteful consumption and do not address the energy poverty. All words that, with the last name of these words, signify that the narrowing window of opportunity to secure a safe, sustainable, and resilient future for all that is set in the IPCC is even narrower if we look at the pathways that we're currently going. So hope lies only on us, on what happens in our societies, in our communities, and how do we respond to the injustice of who gives the decisions at the higher levels. So we know that most of the solutions are there to make ourselves more resilient and to fight for climate justice, but we need to continue creating those enabling environments and the right avenues to work together and implement the solutions in an accelerated manner. The last chance for climate justice comes within the power of law and the defense of the most affected, making us expectant of the advisory opinion outcomes and how can this clarify as well the responsibility that states have and what a best practice of the AOs on multi-stakeholder collaboration there are indeed. And we need this to really understand how do we expect the Paris Agreement to operate and what can be the legal consequences to help those collective efforts to really achieve low emissions and climate resilient pathways and at least have a habitable way forward. So we need clarifications in these obligations and what can we do to fight back and work together to take civil actions to make the states accountable for their responsibility with human rights. So I welcome this panel to give us some insights on what are you doing and what can we do together to fight back. Thank you so much.
Thank you. Thank you so much, Jen. And as you say, I think there can be many frustrations with the way that the UNFCCC works, but I personally find a great deal of hope and vision for the future in the work that you do and the work that other activists like yourself do. So thank you for being here and for sharing your testimony with us. We really appreciate it. We'll go online now over to Chile with Maria Sujkowska from Corporación Norte Grande, who is going to be speaking to us about the work that her wonderful organization is doing with frontline communities. Maria, I'd love for you to introduce yourself and the work you do, and also we know at the heart of climate action are frontline communities. So if you can walk through the work that you do with indigenous communities in northern Chile and explain a little bit more about how this fits into the landscape of accountability.
Hi everyone, thank you very much for the introduction. My name is Maria Sujkowska. I am representing Corporación de Estudios y Desarrollo Norte Grande. It's a non-profit organization from the north of Chile, as you're mentioning. I'm sorry, there's a bit of echo on the presentation that I will be making, so I just gonna take off my headphones off. So I'm working with many projects in the north of Chile, but among them we are working with the indigenous communities, as you're mentioning. And thank you so much also, Jen, for the introduction. NGO that I'm representing, CNG as an abbreviation, has offices in Iquique and Arica. This is north of Chile, and we have more than 30 years of experience of working with projects related to rural development, sustainable development, and environmental protection in the territories of coast, Andean valleys, and Altiplano of the region of Tarapacá, and also beyond that region. We are sharing the passion to support all forms of human organizations interested in carrying out actions that contribute to the improvement of living conditions of the communities. CNG, throughout its history, has strengthened links with the public and private environment, which allows the creation of activities that support sustainable development, agriculture, livestock, artisanal fishing, rural tourism, and volunteering, and through efforts for local governments, articulation, territorial advice, and support for productive projects, and for the communities, always at the forefront. CNG's direct and on-the-ground work with the communities, together with the trust of social organizations, allows it to act with them, working in technical and community complementarity, aiming efforts to achieve the objectives of the 2030 Agenda and others. We understand that it is relevant to be flexible in exploring creative, adaptive, sustainable, and long-term solutions. And as such, during the period of 2023 and 2022, CNG accompanied a small indigenous community in the north of Chile in the formal indigenous consultation process regarding large company projects subject to environmental impact assessment standard, study standard contemplated in the Chilean legislation. This kind of dialogue, the consultation process, aims to reach an agreement or obtain consent regarding legislative or administrative measures that may directly affect them and their traditional ways of life. We find it important to mention that the community that participated in the consultation process is located in the territory of Atacama Desert, where the climate is characterized by being extremely arid, where the average rainfall is 0 millimeters. These characteristics are even more important when we are placing this community in the context of the threat coming from climate change, desertification, and the effects of interventions coming from the industrial processes. The main purpose of CNG in this consultation process, a matter agreed upon with indigenous communities themselves, was to equate the technical discussion regarding the possible impacts of indigenous ways of life that may occur from the operation of an industry, objectify them, and properly weight them in a manner to formulate compensation, mitigation, or voluntary measures as appropriate. At CNG, we find it very important that the indigenous worldview, called in Spanish cosmovisión, remains as the most important component for the well-being of the communities. Community principles and mutual commitment are always at the forefront of our work and are important for the work with and for indigenous communities. We believe that only through valuing the traditional ancestral indigenous knowledge, we can continue mutually with our work in defense of the territories. It is important to note that these are not alliances that complement only logistical efforts, but we are inspired by the ideology of permanently promoting a transition from a culture of governance, focused on intersector efficiency, to one with a holistic approach that promotes the design and implementation of plans, programs, and public policies expressed in renewed, new and better efforts to improve our progress in defense of the territories. It is relevant to add that this holistic approach, the values and practices of reciprocity and complementarity typical of the Andean cultures that have inhabited the territories of thousands of years and where CNG performs its actions, are very important and esteemed, not only for this process, but for all the processes that we are executing.
Sorry, wait. We good? Thank you. Thank you so much, Maria, for giving us such an excellent overview of the work that you're doing. And I really liked how you mentioned making sure that the different ways of knowing are equated with one another. I think that's really vital, and I'm glad to see you guys prioritizing. I was wondering if you could speak a little bit more about the value of strengthening community participation in public policy, as you all do at CNG.
Yes, of course. Thank you so much for this question. I'm going to take the headphones off again for this technical problem. At CNG, we are convinced that community participation is crucial for safeguarding of their rights. For all indigenous consultation processes in which CNG has supported indigenous communities, they have been assisted with medium to long-term plans. Additionally, measures enforceable by the authority have been established that seek to strengthen the indigenous ways of life in a highly dynamic cultural and intercultural context, as well as design and implementation of long-term monitoring program on relevant and sensitive natural resources for the survival of these communities. At CNG, we believe that strengthening public policy through contributing to reform technically and accompany indigenous communities is essential. It is important that the communities are able to participate in regulated processes of formal indigenous consultation process. These kind of arrangements are crucial for their safeguarding and enable them to participate in a better way in front of the technical teams of the companies. Participating in all instances offered by public policy is essentially an exercise of rights in circumstances that imply exercising third-generation rights, economic, social, and cultural rights. It is important to note that indigenous communities and their participation is related to their indigenous worldview, where nature plays a central role, as they are there as a collective community, and they have the collective motivation to protect their territories so that they can safeguard a lasting ecosystem and cultural advantage. The maintenance and protection of productive spaces not only focuses on the economic activity of the communities, but it also has the purpose of contributing to and valuing a multiplicity of cultural and environmental benefits that are related to the ancestral practice of indigenous communities. Additionally, with increasing effects of climate change at their territories, it is important that they debate the intervention of industrial processes in their area. As such, incorporating the indigenous communities in this kind of processes ensures that they are not only not being excluded from the decision-making. Protection of their territories means that they can directly contribute to safeguarding of their ways of life over time, providing them with tools with which they can participate in consultation processes are essentially a way to strengthen the ability of community participation, where they can do so each time they need to defend their rights or contribute to public policy making. We really believe that these kind of experiences should be replicated in other territories so that more and more communities can actively participate in the defense, but also the exercise of their rights in defense of their territories. Thank you so much.
Thank you so much, Maria. And I really want to pick up on what you just said there, which is just making sure that this model can be replicated, because, of course, Northern Chile is not the only place in the world that requires better consultation of its indigenous peoples. So I think the work that you all are doing provides a really good roadmap for others who are hoping to do the same kind of inclusion in public policy. So thanks so much, Maria, for joining us. We're so glad that you were able we were able to make it all work with tech. And so thank you for this wonderful tech team to making us have such a diverse panel from across the world. Fantastic. And just a small note is that we have actually Nigel Pleming with us, who will be speaking later with Ivano on BIICL. I'll introduce him formally later, but really grateful as well to the tech team for getting that sorted. So thank you. We're excited to have another speaker further down the line. Great. So we'll pass down to Dr. Delta Murner, who I previously introduced with the Union of Concerned Scientists. So Delta, we're seeing obviously an increase in litigation, both as a result of increased and more severe climate impacts, but also because the science has improved to a level where we can actually use that science in litigation cases. So I was wondering if you could speak to the distribution of scientific research that can underpin legal demands for loss and damage. Thanks.
Thank you so much. Yeah, so science has a really pivotal role to play when we're trying to understand and determine loss and damage. Yes. Okay, great. Sorry. Science has a really pivotal role to play when we are looking to understand and determine loss and damage. And so science can really help to provide the evidentiary backbone for such cases. Loss and damage cases seem likely. I mean, we're still waiting to see as they go through the courts, but it's likely that we're going to need to understand really what impacts are caused by climate change. So scientifically, what is actually climate change versus natural variability. We're going to need to understand the actors that caused the climate change. So who's actually responsible for the emissions that result in that climate change. So for example, carbon majors or individual countries. And then we'll also need to understand how plaintiffs are impacted by climate impacts and what specifically were the losses and damages that were faced from these impacts. So science can help to answer some of these questions. However, as we look at the current distribution of cases, of climate litigation cases, we see that although the geographic spread of cases really has begun to diversify, they're still predominantly filed in the global north. There are a number of reasons for this, but I would argue that one of the limitations for cases in the global south is the necessary research to establish the causal chain that we're talking about. So when you map the scientific studies that are designed to really address these questions, you'll see that there's entire regions that are missing from this map, from the overall picture of where these studies are. There's a bias for this in the global north because of resources, but there's also fundamentally, many of these cases require baseline data that's been collected over a long period of time into the past, and there are regions that simply don't have the historic data and therefore don't have the regional studies that can really come from that. So there's two important things to consider here. One, I think, is a call to lawyers in the room to think through the reality of these limitations. So I think we need to think strategically about how to prevent kind of unrealistic legal burdens in the global south, so that we're not expecting the same exact kind of replication of scientific studies to be happening in those regions, is certainly one piece of it. We also need to look to scientists to really expand the way that they are doing their work, right? And to be thinking of new methodologies in this space, which is absolutely possible. And an example of kind of a creative way that scientists are starting to explore this is some work that has been happening for more global modeling. And there's work out of Climate Central that is actually looking at global temperatures on a daily basis. So every day they're looking at global temperatures and they're saying how that's impacted by climate change. So they did some work, and you can see kind of during our time here at COP, they looked at heat, and every day except for one day, there's a climate signature where that day was hotter because of climate change. So we're starting to see these tools that are developing and are diversifying and are starting to truly be global in nature, which is really critical.
Thanks so much, Delta. And I really like having a call to action to the different stakeholder groups in the room. And just a quick plug for World Weather Attribution, which is some of our colleagues over at Imperial College London doing really fantastic work on attribution of extreme weather events. Delta, you spoke a little bit about the fact that some of the gaps on loss and damage, or fully understanding loss and damage in the global south are research gaps. And I was wondering if you could speak to the areas that could be further developed apart from those baselines in order to add to the credible base of evidence for loss and damage.
Yeah, so there's a number of really important scientific areas to be looking at loss and damage. And often, I think, when we think of climate science, we just think of the physical science. But it's really important to know that that is just one small piece of it. I think it's also really important to say that the science that we're looking at is science that should really be reaffirming the lived experiences. And that's where a lot of this work needs to be starting from. So as far as kind of general areas that are really key for as we're looking in this space, I would say first we need to understand kind of the attribution science, which is the science that allows us to attribute what's happening with a physical event to climate change. So very few events, although increasingly so, we see events that, very few events are really 100% caused by climate change, but they're impacted by climate change, right? Maybe a rainfall is more intense. A hurricane moves differently because of what has happened with climate change. A heat wave is more intense or more frequent, right? So it's understanding kind of that different variability because of climate change that is happening. So attribution science allows us to do that, to, again, establish that causal chain between human activity and climate-related disaster, which is crucial for holding polluters and others accountable. So that's one important pool of science that's starting. Another really critical area of research is non-economic loss and damage. So as we just heard from Maria, she was talking about kind of the cultural rights of the populations of where she's working. This is an incredible area of loss that we are looking at from climate change. So of cultural rights, of language, of homelands, of things that you can't necessarily quantify. And science historically has focused on things that you quantify, right? Especially in the physical sciences and often in the social science as well, right? There's, again, kind of a bias towards the types of things that we can quantify. And as we bring loss and damage to the courts, we need to make sure that we are equally lifting up these non-economic losses and damages. And well, there's a role for community space in that, and there's also a role for science to be lifting that up, to be prioritizing that type of work. And then finally, I would say another area that is kind of the next step in a lot of this work, and I think is the logical next step as we go into the courts, but it's really the economic research. So we need the research and the tools for calculating economic losses to climate change that can help to aid in estimating what those damages are, what that really looks like at the end of the day. So, while science is invaluable, again, it's important to acknowledge that there's limitations, especially in regions with limited baselines, and that science should be viewed really more as a guiding tool rather than a bar that needs to be met, and an inclusive approach that combines scientific insights with community-based knowledge is essential for navigating the intricacies that we're going to see with loss and damage, and for more equitable cases moving forward.
Thank you so much, Delta. And I think a sort of repeating theme is just making sure that we are looking at different ways of knowing in different disciplines and valuing them equally, because climate change is so complex and interconnected. Just a note to everyone in the audience to please think of your questions as these amazing panelists are speaking, because we'll have time for questions at the end. So I don't want to abuse chair's privilege and ask all of the questions that I have, so I would love to hear from you. Great, thank you so much. We'll move on to Leah from Client Earth. So ultimately, all of this knowledge, both the scientific knowledge that Delta just laid out, as well as the community knowledge and the youth knowledge, can all be used as tools to harness the legal system to our advantage. Can you speak more to the advisory opinion work that you all are doing at Client Earth that is operationalizing all these different forms of knowledge?
Sure, hi, thank you so much for having me. So Client Earth is a legal organization. We use the law for more environmental and climate action. And in the context of the advisory opinions that you just mentioned, we've been fortunate enough to work with some of the main actors behind these advisory opinions. And so I'm just going to give like a little bit of an overview to bring together some of the points that the panelists before me have raised. And I think that really beautifully demonstrate that multi-stakeholder collaboration and maybe, I know in sort of this somewhat difficult moment, maybe do also give a little bit of hope. So there's currently 3 advisory opinions pending before different international courts and tribunals. And the first one was launched in December of 2 years ago, by the Commission of Small Island States. So that is a Commission of Small Island States that was actually formed by Antigua and Barbuda and Tuvalu, so 2 small island states, during the COP26 in Glasgow, so 2 years ago, because of the frustrations felt with the process, with the political process. And so that question that was then put to the International Tribunal for the Law of the Sea, the tribunal tasked with overseeing the correct implementation of the UN Convention on the Law of the Sea, was asked to clarify whether human-made greenhouse gases qualify as pollution under the convention, and if so, what that meant for the obligation of states to reduce and control pollution of the marine environment. And so there were a large number of states that participated. The hearings took place at the tribunal in Hamburg, Germany in the fall of this year, and we're now waiting for the advisory opinion. And so in that example, we're seeing a group of small island states come together, again, or just to reemphasize, born out of a moment of political frustration, to clarify the legal obligations that actually already exist on states and how those legal obligations interact with the reality of the climate crisis that really touches upon sort of all aspects and areas of law. Then there's a second advisory opinion pending before the Inter-American Court of Human Rights, so the Regional Human Rights Court for the Americas, that was submitted by Colombia and Chile, that is asking sort of a broad range of questions, but essentially trying to understand how the American Convention and the obligations on states under that convention, so the human rights obligations on states, again, interact with the climate crisis and what the climate emergency means for the rights of future generations, for the rights of indigenous groups, for the rights of other groups. And so the deadline for that is actually next week, as some of us in this room probably know and are very well aware of. And so, again, it's another framework that's, or it's another set of rights and another legal framework that's obviously impacted by the climate crisis. And as Delta just, or as everyone before me has, emphasized, the science is there. The science is very clear on the impacts of the climate crisis. It's very clear on how the climate crisis already affects the full realization and enjoyment of human rights and how it's going to continue to do so in the future. And that's based on the science, but that's also based on lived experience that we're told every day. And then the last advisory opinion is the one pending for the International Court of Justice, and that is based on the tremendous and incredible efforts of a group of Pacific Island students that sort of, devised in their classrooms, in their university rooms, to take, as they say, the world's biggest problem to the world's highest courts. They've since been joined by a global movement of youth advocates, and then their cause was taken up by the island state of Vanuatu, who led an incredible effort and by consensus was able to pass a UN General Assembly resolution back in March. And so they're also asking to understand the obligations that arise under a number of different international instruments, including all of the human rights treaties as well as the UNCLOS, and how those rights and obligations arising under these conventions are impacted and have to be interpreted in light of the climate crisis, and with a particular view to future generations as well as small island states. And so I think what for me personally, so as I said, we've been at Client Earth, have been very fortunate to support these efforts, as we think it's, first of all, an important point in time for the development of international law. Much of the international legal framework that exists today was written, drafted at a time before sort of the climate crisis was, had progressed the way it has today, but also was at the forefront of sort of global conscience. And to make it very clear, these international legal frameworks obviously have something to say about the climate crisis, because as I just said, and I believe everyone in this room is probably aware of, it touches upon all of these different areas of law and different areas of life. And so I think maybe how it also ties back to some of the other things that my co-panelists have said, it's, we're seeing these communities and groups of actors use these legal tools because of the frustrations that they either feel with political processes or even being excluded from the political processes. We're seeing a lot of incredible mobilization by youth groups. Youth activists are oftentimes, or youth in general, are oftentimes excluded from the political processes that lead us to these points in time, either because of voting ages, and so they can't actually vote their political representatives, but then also if we look at average age of sort of parliamentarians, they don't really reflect youth either, and so we're seeing sort of the exclusion. Then obviously there's the whole issue of future generations and those, many of those that will be most impacted not being born yet today. And then we're seeing these small island states, really kind of being the champions of international law and really being the champions of pushing these progresses forwards, because these international legal processes can help clarify the obligations and can hopefully also help in kind of taking forward some of these political processes that we're seeing sort of circle around the same issues over and over again. And by having some of that legal clarity, all of us really hope that we can push these political processes in more constructive and more progressive ways. And maybe just sort of a final thought on this. At Client Earth, we were also fortunate to support a group of 8 Torres Strait Islanders, an indigenous group from the Torres Strait Islands, in their claim against their country of Australia before the UN Human Rights Committee. And that Human Rights Committee made very clear that the international legal framework, or the International Covenant on Civil and Political Rights, does have something to say about the climate crisis, that human rights do have something to say about what states need to do in fact of this, huge threat to the enjoyment and realization of human rights. And so we're really hoping to see that the other courts pick that up, and we're hoping that this will sort of be another pathway to really more ambitious climate action on a global scale.
Thank you so much, Leah. Thank you for laying out all that amazing work that's going on with the advisory opinions and the work that you guys are doing in collaboration with so many other amazing groups. I wanted to ask just a quick clarifying question: is if everything goes the way that we would like with the advisory opinions and we have a strong outcome, what would that materially change about coming to a COP and a country is bound by, for example, the recommendations made or the advisory opinion to the ICJ? Does it change their negotiating position? What would be different?
So advisory opinions are not legally binding. However, they are authoritative statements of the law, meaning if a court says, so let's say, so before the International Tribunal for the Law of the Sea, I'm going to use that as an example because we've seen the legal arguments made. If the International Tribunal for the Law of the Sea says man-made greenhouse gas emissions amount to pollution under the convention because states are under an obligation to reduce pollution of the marine environment, that in turn leads to the conclusion that states are under an obligation to reduce greenhouse gas emissions under the law of the Sea Convention. Thereby, if that legal obligation on states is clarified, in my view, it would then, if we want to take it back to sort of the political negotiation level, that gives leverage because it says, hey, those obligations to reduce emissions and sort of the circumventing of that obligation we're experiencing at the moment, but actually that legal obligation exists under other frameworks. You can't circumvent that obligation in political processes, is a really, really important tool to hopefully push along some of the standstill that we're currently seeing.
Thanks so much, Leah. That makes it very clear. It's sort of like triangulating to make sure that the obligations are consistent across all the different frameworks. So thank you so much. Fantastic. So we'll move to our interventions from BIICL, which is the British Institute of International Comparative Law. We are lucky enough to have two speakers from BIICL with us. So glad that Nigel Pleming can join us virtually. Nigel Pleming, KC, is a barrister at 39 Essex Chambers and also honorary senior fellow at BIICL. And we have Dr. Ivano Alogna, who I introduced briefly before, who's the research leader in environment climate change law at BIICL. So we're excited to have you both here today. I wanted to talk about the toolbox that you've been putting together because you've been working on the creation of this global toolbox on corporate climate litigation. And Nigel, I want to turn to you first. You're an experienced barrister in the environmental law field and the chair of the core group of this project. Would you mind explaining to us what this toolbox is and what was the reason behind putting it together?
Of course, and thank you so much for the introduction and to the organisers who've managed to put me online so efficiently and quickly. I wanted to, as you say, to speak about the genesis, the driver for this project. And there are similar projects dealing with litigation. And what's special about our global toolbox on corporate climate litigation. If I could start with the driver or the need or the genesis, for me, it started in early 2020 with the International Bar Association, which produced and published, and this is the title, a model statute for proceedings challenging government failure to act on climate change. The problem revealed in that title and confirmed in the text is that the model statute was deliberately restricted to governments and, to use the words in the introduction, does not speak to or promote any actions or remedies against corporations or private parties. That phrase is preceded by these words: the model statute does not prejudge the outcome of any such potential cases or speak to the merits under the laws that control a specific jurisdiction. That's the same for BICL. It doesn't seek to promote litigation against private actors and is not directly concerned with the merits or outcome. It seeks, on an international and comparative basis, to fill that important gap, and in relation to private actors, not governments, to identify and examine causes of action, procedural issues, including such topics as standing, expert, scientific and economic evidence, remedies, etc., that are likely to make this type of litigation more efficient, speedier, so that such cases in the climate emergency are resolved as quickly as possible, consistent with justice and the rule of law. Ivano can deal with the mechanics and the details. The importance of the project, why does it matter? The project is important, in my opinion, because BICL is engaging with a number of lawyers around the world, currently from 17 jurisdictions where there are rapporteurs, and there is also an international working group, and together they comprise about 200 experts from legal practice, academia, the judiciary, science, and economics. And their work feeds into BICL's analysis, which in turn is fed back to those jurisdictions, and the debate exchanges continue. It is hoped that the project and the continuing dialogue will lead to the clarification of this complex field of knowledge and practice. Thank you again for allowing me to join you.
Nigel, and appreciate all the work that you at BICL are doing to streamline this landscape, and as you mentioned, making sure that we can win these cases more effectively and clarify the landscape. So Ivano, you're the project research lead, and you're an expert in comparative and international environmental law. Would you mind walking us through the approach and the methodology that was used to create the global toolbox and its next steps that you foresee?
Sure. Thank you very much, Alex. I don't know if I have to speak here directly. I think I have a couple of slides just to help you out with this. So this is what you see is a screenshot from our website. So the title of the original title of the project is A Global Perspective on Corporate Climate Legal Tactics. We basically tried, as we developed, as Nigel said, this research, this comparative research on 17 countries in this first year. We tried to understand what are the possible avenues that have been used and can be used in the different countries, and try to understand what could be the next steps, what could be the next kind of causes of action, procedure, remedies that we can use in these kind of cases around the world. So it's a global toolbox, as you can see in the next slide, because in a way we try to do this comparative analysis, we try to see a little bit how these different cases globally, we use a classic comparative methodology, which is the Common Core methodology. So we are trying to give everyone the same kind of question. So we give a questionnaire at the beginning to 17 national rapporteurs, which are academics, because we needed somebody that can convey in a neutral way what we are finding. So of course in the group, as Nigel said, we had also practitioners, we have scientists, we have judges, but we really wanted to catch what were the news, what were the interesting points, the interesting causes of action used. And then also very important is to see the lesson learned in other fields, because I think that at this point, if we want to make an advancement in this field, it's really important to try and see in the other discipline, in the other branch of law, what's happening, what happened. And so looking to tobacco litigation, toxic torts, to many other kind of fields. For example, we are studying all the different causes of action, from criminal law to tort law, human rights law, anything that can help us understanding what could be the next steps. So in a way, there is a lot of strategic perspective, but we have also this interdisciplinary thinking, because as you understood from this panel, which is quite composite, quite complementary, we are coming at the end because we've seen the problem, we see what Genaro said about a little bit this gloomy perspective coming from this COP, another COP where probably we weren't, we didn't, deliver what we expected. And then the science, and then the science that is fundamental, because as Delta said, attribution science is fundamental. We need it, and that's why we work a lot with the scientists in this group. There is, as part of our core group, there is Heede, which was behind this methodology to understand, to calculate the percentage of responsibility in the global crisis, in the global emissions from each of the big carbon majors. And of course, we need also the practitioners, because without the practitioner, we cannot do the litigation. And so, thanks also to the great work by people like Client Earth, we are really trying to put together a team, an international team, international working group, to try and understand better how we can improve this kind of litigation. Of course, we are a research institute where we would like to prepare the tools for everyone, and also, in a way, as you can see, encourage corporate actors to mitigate their litigation risk. This is quite important. It's a dialogue. We are not... Next slide, please. And so this is a little bit how we did this. We have this core group. We have people as Nigel, so great practitioner, Ingrid Gubbay, Richard Lord. We have great scholars like Michael Gerard from Columbia University, Chintian Pao from the Wuhan University in China. We have Emmanuel Uigire-Shabia, who is now the Minister of Justice in Rwanda. We have scientists like Heede, but also Naomi Reskes. We have judges like Brian Preston from Australia, or Marc Lemon from France. So this is our core group. These are the people that, in a way, suggested us the right steps to take. Where around them, we organized, we hired these 70 rapporteurs these academics from this country that you see on the slide, and then with each of them help us create 17 national groups with all these different stakeholders working together to expand our knowledge in this. And this working group, this international expert group, is still growing, and I hope that will continue in the next year. Next slide, please. And so this is a little bit something that we are launching tonight, which is this corporate climate litigation platform. We are going to start with disclosing this corporate climate litigation resources platform, which is still a work in progress, of course, and I hope that will be also in the next years, because we are trying to put together all the important books, papers, all the important knowledge that we have around the world on this topic. As you can imagine, with this wide perspective is really also incorporating scientific papers and, of course, papers that are spanning from very different aspects of law. And basically, with this corporate climate litigation platform, we are going to start building up with what already has been greatly done by the Sabin Center, Columbia University, by Grantham Institute, with the policy and law databases. We are trying to create in the next year a corporate climate litigation database, which is going to be used by practitioners, hopefully also by judges, by anyone that is interested in local communities, governments interested in this kind of litigation. As we've seen, California in September started this new case against carbon majors. So as we see, this is a real possibility. And next slide, I think, is the last. Yeah, these are just some activities. So in the first year, we had many workshops. As I said, the comparative analysis. So we had really on the three axes, the causes of action, the procedure and evidence, and the remedies. And next year, we are going to have a launch of this toolbox, which is going to be in London. Everybody is invited, of course. And we are going to have 17 national conferences where we are building up these national teams in each of the country to make sure that each country is responsible for the level of knowledge that they are proposing us, and each one is going to contribute to this global toolbox. And we are going to organize 5 regional summits, as you can see in the different continents, and it's going to be the moment in which we are going to attract, to test, to disseminate the toolbox, and to discuss with many other experts, judges, and practitioners and academics and scientists from many more countries, from 17 probably to 50. And there is where we are going to have also some judicial briefings for judges. And we are going to have at BICOL also a new corporate climate litigation course to be added to our climate change law and climate change litigation course. And and as I said, the database and many other outputs, we are going to publish also an edit volume on this and many other things. So this is a little bit the presentation of our toolbox. I hope that you are going to join us in a way or another, and at your pace. That would be really great, because we are trying to do something very collaborative with everyone. Thank you very much.
Thank you so much, Ivano and Nigel online. And I think it's just been a really wonderful panel to hear you all attacking this big problem from so many different perspectives. And as you said, Ivano, and I just want to re-emphasize it, that the interdisciplinary cooperation is so key. And it's really, I'm really glad to see you all on this panel, but also here today in the audience, because I'm sure we have people who represent all these different types of stakeholders, from legal to science to youth activists. So it's good to see us all together. I'll go to questions now, actually. So we have 2 roving mics, which I'll just seamlessly hand off now. And please just let us know briefly your background, a little bit, what you represent, and your question and who you would like the question to be directed to, and try to keep it somewhat brief. Thank you.
Hello. Yes, thank you so much for your presentation. My name is Maria Naya. I am a PhD student at Cornell University. And my question, I think, is for Leah, and also I think Ivano could also shed light on this. But Leah mentioned briefly how, for example, the judgments of the different 3 tribunals could impact the negotiations. And I was wondering whether you see any kind of impact from domestic litigation in the kind of, negotiations are shaped, or I don't know, stakeholders are behave in this kind of high-level scenarios. Also, a specific question for Ivano would be like, how did you choose the countries that you are working with? I'm personally from Colombia, so I was wondering like how other countries could join or could participate in that platform as well. Thank you.
I'll go first. Thank you so much for your question. So, I mean, I think as we're seeing sort of action increase at the international level, obviously there's been a lot of action at the at the national level. Just most recently, I think it was last week or the week before in Belgium. And so I think what we're seeing, and I'll give the example of Germany because that's where I'm based. So there was a successful court decision 3.5 years ago. And I think what we're seeing, what that means, and I mean the court decision addressed the national framework that implemented what was decided at the international level. And so the court decision then challenged the government's implementation of the national framework, and said essentially what the government is doing at the national level is not in compliance with its obligations, both not under what the national framework says in certain points, but also that the national framework itself wasn't sufficient to meet its obligations, specifically in relation to the fundamental rights granted under the German Constitution. And so what we've seen from that at the national level is a partial ramping up of ambition. We've also seen that even though there is that very strong court decision, that we've also seen that not all of it has been implemented, which then has led to follow-up claims. And so I think what we're seeing is that by using those legal tools, it's a way of holding governments to account. And so I think that even if we're seeing that they're not then at all times or maybe not implementing those national decisions to the fullest extent or completely, we are seeing that they are taking them serious to a specific level, and at the same time seeing that then that feeds into how they at times may also interact at the international stage, and how they approach certain negotiations, because they know that people at the national level are paying attention and are taking a look at how these governments are meeting their obligations at the national level. Now, I do have to add that not all countries obviously have national level climate frameworks, and so we are now working as an organization on making sure that more and more countries do. And so we recently drafted sort of a first national framework for Poland, and we're hoping to do so for other countries as well, because exactly of that effect that I just mentioned. We need to see these international obligations be translated into national level obligations, and we need to see that because we need to see concrete action at the national level, but we also need to see accountability at the national level. And so I think it's not always a sort of it's not just that one decision will sort of then solve it all at the national level, but it'll kind of contribute towards strengthening national level action and also the accountability that then hopefully sort of feeds back into the international processes as well.
Yes, so for the choice of the countries, basically when we start this project, that were the 17 countries which we found everywhere in the world corporate climate litigation. Now there are more, because now as you've seen, there is like the Olsen case in Switzerland from the Paris Islanders. There are many other cases. There is also Colombia coming up. So in this moment, we have many more countries, but when we started, that was that. And yes, so what I said before is basically that next year, 2024, we are going to organize the regional summits, and the one for Americas is going to be in Brazil. So the idea is to organize in a place that is a little bit easier to reach for Latin American countries, because the other countries of this continent are US and Canada, and as you know, they have already their fair share of interesting cases. But we want to involve as much as possible people coming from Latin America. And so Colombia, of course, is one of the main countries that we are going to work with. There will be also Chile and others. In this moment, we have some good connections and work already with some practitioners and scholars from there. And so, yeah, one of our hope is to enlarge during this regional summit also to other countries. So, of course, if you are interested, please just get in touch with us, because that would be really a good opportunity for collaboration.
Can I add something? Yeah, so just to add to kind of from the science perspective, which is slightly different than the question that you're asking, but we've had the honor to be able to work on a number of these advisory opinions and are working on them kind of moving forward. So with ITLOS, we were able to partner with 2 states to help with their submissions. And it was really remarkable to be able to see the improvement of the communication of science to the courts and kind of hearing the ITLOS proceedings and how people were understanding the questions that they were asking and really how much that has moved forward, and through the ITLOS process, how much that understanding of the science has also been able to move forward is something that was kind of powerful as a scientist sitting in that space and just seeing that. And I think that opens up it normalizes kind of the courts understanding the science, listening to the science in those pieces. And I think we saw kind of a similar piece with the case in Montana in the US, which was a smaller human rights case. It was a state-based case there that was a positive win, and I would say was kind of unexpected. And the US does not have the strongest human rights laws. It was not kind of the approach that folks thought might even be the most strategic. And it was really powerful to watch that case again for the way that the science was listened to, understood, and respected. And I think, a few years ago, we would have said, oh, like, the courts and the judges are going to be questioning these pieces. It's not, like, how do we explain them? But that wasn't the case at all. And even in Montana, it was to the point where the state was planning to have some scientific experts who kind of opposed the really consensus science, and they ended up pulling those experts and they didn't let them testify, and they ended the case early because the case that was made around the science and the youth that were impacted was so strong to kind of start with. So I think that is a trend, and we can see that really strengthened and see that communication of science and impacts really strengthened through these processes. With the Inter-American Court, we are seeing the kind of the opportunity with the Inter-American Court as a moment to even continue to push, right? Because they are a court that has accepted that and are willing to kind of take more advances. So we had the opportunity to work with a number of other groups on an intervention that, because the Inter-American Court also allowed interventions outside of the states, that is actually looking at state obligations for corporate actors. So, how do you get to corporate accountability kind of through these state mechanisms, what that looks like, and kind of laying out some of those arguments. And I think that building those briefs and again, kind of presenting those arguments to the courts has the potential to normalize and expand those arguments. And then with ICJ, and I would argue with the European Court of Human Rights, kind of all of the cases that we're seeing there, kind of at a similar level, I mean, not the same level as the ICJ, but, kind of also having real impacts on how we think and frame human rights. And importantly, I think that ICJ will hopefully get at more of the normalizing the cultural heritage pieces, which, some of the work that was already mentioned has started to do, and there's real need to grow that. So, yeah, thanks.
That's fantastic. Thanks so much. And I think you called some of the folks who are working on that ICJ opinion into existence, so they've just walked into the room, which is great. So thanks for being here. Just a reminder that we have our 2 online speakers as well. So if you have any questions for Maria or for Nigel, please do direct them. But we'll.
There's one.
Oh, there's one online. Great.
There's one question.
Yeah.
From online, from Clima. To what extent can litigation contribute to climate justice ahead of government responsibilities over corporate responsibilities?
Sorry, can you repeat?
Yeah, could you repeat?
To what extent? Can you?
Oh, there we go.
No. To what extent can litigation contribute to climate justice ahead of government responsibility over corporate responsibility? Not directly to anyone in particular.
Yeah.
Ivano.
So I believe that one of the issues that we have at this point is that we are dealing with a very complex kind of climate governance, which is a little bit slow. And of course, when we were talking about the negotiations in the last days, when we discussed all the different elements that we have to touch upon to be sure that we advance, realized that we need a lot of coordination between countries, and sometimes it's very difficult. So litigation in a way, and the fact of putting a little bit the pressure on states is one of the best possibility that we have to move this kind of climate governance. And so there is a big responsibility of states on this, and probably negotiating this kind of issues, climate change is the best option that we have, but considering also the current political situation that we find in many countries, probably litigation is also a great way of doing it. Corporate climate litigation for us at BICOL, as Nigel explained, was like a sort of evidence, because we saw that there is a clear, evident problem everywhere. There is a political scientist issue that is the regulatory capture. And with corporate climate litigation, we can really try and circumvent the regulatory capture. So the country are not more bound by their companies, by the lobbies that are in a way pushing them in one way or another. And so we go directly to those that apparently, according to the scientists, they contribute for 70–80% of global carbon emissions, which are these companies. And let's try to discuss with them. Let's try to understand if they want really to do this energy transition. And so the responsibility is really important, is going to be pushed in that direction toward companies. Of course, the states, they are already responsible also for their NDCs, even though many people say the Paris Agreement is soft law. It's not.
Maybe if I can add to that, I think there are sort of two interesting things to observe in that respect. So as Delta was just talking about with the Inter-American Court of Human Rights, part of the questions before the court are also trying to understand the obligations on states in relation to business actors. And I think that's a really important component of it, just because, as Ivano just said, and as others in the room have said, the massive contribution of corporate actors to the climate crisis, but also the responsibility that they have and the need for frameworks, for clear frameworks and clear obligations on states to determine or to actually say that states also have to regulate the conduct of business actors in relation to the climate crisis is really, really important. And so I think that's something that many of us are hoping to see and pushing for in relation to the Inter-American Court. So there's the international sort of law component. I think in sort of the national law component, I think one of the sort of really interesting developments in recent years has been, specifically in the United States, we're seeing a lot of corporates being taken to court for having been aware of the impacts of their business practices and their contribution, and the contribution of their business activities to the climate crisis, but having lied about it, having sort of hidden the evidence, twisted the evidence. And so I think that's another really interesting development where, correct me if I'm wrong, but where I think it's actually state governments or local governments taking corporate actors to courts. And so I think there's sort of two different really interesting strands to observe. So for one, state duty to regulate business conduct, but then also states actually holding businesses themselves to account.
Thanks so much. Is there a question?
Did you want to?
Actually, we'll take maybe two at the same. So we'll take you, and then we'll take you, and then we'll answer them, if that works.
Hi.
Oh, you have. Oh, sorry. Nigel was just going to come in, I think, on the previous question, and we'll take your question.
Thank you very much. It was the earlier question, the reference to Colombia and being added to the existing list of 17 countries. Our ambition is to expand that list, but the point that Ivano missed is that we're a charity, and the charity needs money to cover the 17 countries, and any expansion requires more funding. So it isn't as easy as just saying we'd like to add you. Of course we would, but we may need to consider additional funding to do it.
Great, thank you so much,
That's
Nigel.
all I wanted to add.
Thanks, Nigel. Go ahead with your question.
Is this working?
Yeah, I think so.
Hi, I'm Siobhan. I'm a lawyer by background, and I'm currently studying at Oxford. I have two questions, but can I ask both? Or?
Yeah.
So my first one is, I know Delta said that one of the biggest challenges of bringing cases in the Global South is the lack of data and the lack of science. And I would agree with that, but however, looking at the successful constitutional law and human rights cases that have recently been brought in the European Union, in Germany, in the Netherlands, and France against governments, I feel like the basic IPCC science was enough to hold those governments to account. Without, I know it's trickier when you get into like attribution science for specific events and loss and damage, and we've not seen success in that regard. However, knowing that the general science is enough for human rights issues, we haven't seen that success translated to the Global South. And my concern is that this is mainly because of low capacity, non-independent judiciaries, lack of respect for the rule of law. And so how do Global North institutions support that in a way that's positive? And I know that there's some forums, so like I know in the Nigeria Delta, claimants have now been allowed to sue Shell in London, but that was after, because of Shell's head office being in the UK, but that was after an 11-year battle, so these are quite big challenges. That's my first question, and I guess the question is to everyone about like, how do we interact with that problem? And the second one is, again, we've seen success on reductions of CDR, of GHG mitigation targets. And I wonder whether we will see litigation or action on removals, the over-reliance on removals, which we know are in corporate pledges and also country pledges. And I guess I'm really unclear on how the science on that would work, what constitutes over-reliance.
Thank you so much, Siobhan. I'll just take the second question so that we can, and I'll remind you what they are, just so we can get through a few more questions. And we have one more online as well. And we have a third one over here too.
Okay, yeah, I also have two questions.
Okay.
First of all, I understand that the Loss and Damage Fund has been renamed the Climate Impact and Response Fund. Am I right to suspect that that has to do with liability and making it seem more like charity than compensation? And the other question is whether any of you are working or following the campaign to recognize the crime of ecocide at the ICC. And do you think that that would open up new opportunities where there would be actual criminal liability, and also the fact that it includes gross negligence, not just intent, given that it's obviously due to the gross negligence of governments and companies that we are in this mess?
Thank you so much. So just a reminder of Siobhan's question about the basic IPCC science being enough to hold actors to account in the EU, and on litigation of over-reliance on removals. And just because I have to, there's some new research out from Oxford that shows that over-reliance of CDR is in contravention with international legal obligations. So there's that on the legal side, but yeah.
Yeah. So I can start that one, and I hope other people have things to add. I think there's a couple of different questions in there. So one of the things that's important to understand again, and I'm like breaking into the law now, which is not my area, but with cases, there's a taxonomy of different types of cases that you have. So you have mitigation cases, adaptation cases, and we're starting to kind of see the loss and damage cases that are coming through. So the majority, I would say, of the cases that we see in the global north right now are the mitigation cases. And the mitigation cases are often the individuals that are suing their government for failing to mitigate their own emissions. And so that's a dynamic where you have a government who has large emissions and is responsible for mitigating those. One of the dynamics, there's many dynamics, and you named a number of them, but one of the dynamics in the global south is that a number of those countries are not major contributors of greenhouse gas emissions. So a mitigation case in that same way that relies on that IPCC science doesn't make the same sense, right? So suing the Kenyan government, which is responsible for 0.03% of global emissions, is very different in Kenya than it is in the US, or in those spaces, right? The US is a kind of different legal case, so let's say in Europe. So I think that's one dynamic where what needs to be happening and is starting to happen, and folks are doing all over the world, but is really shifting to the adaptation cases in the global south, because that's what's needed, right? Their governments don't necessarily need to cut emissions, and that's a generalization. Of course, there are some governments in the global south that are larger emitters, but still, they're not so that's one important dynamic, and that's an entirely different set of science that comes into that. And then we get into that same type of case with loss and damage, again, where you're saying who is responsible, who are you holding accountable for these pieces. With adaptation, you can argue, right, that the governments have responsibilities to consider adaptation and to make sure that they're spending money in places, right, and to have policies and actions that align with what is needed for climate change. So there's pieces there. For loss and damage, we come into the same place, right? Who is responsible for that? And it's the large emitters and it's corporations, right? And if those corporations aren't in your jurisdiction, you get into what does it look like for litigation that's outside of your jurisdiction, those questions, versus in the US where we are moving forward some damage cases, those models, which I had blind spots to. I was thinking we were kind of like building up a case study that could be used in other places, but the reality is that you have places like Pakistan that don't have industry that it makes sense in country to be suing in that same way, right? So that's another issue of equity that needs to be addressed. Folks want to add to that?
No, I think that was a brilliant response. Just to the science bit as well. I mean, even if we look at a lot of the cases that are being argued, most of them rely on the IPCC. So if we look at some of the European cases, they did use the IPCC science, or then sometimes the way that science was translated into national frameworks, or sort of or interpreted by national scientific bodies, but they still did use that science just because it's so vast, and it's while at times we need to acknowledge the fact that because it's a consensus-based process and the length of time that takes, and again, I'm not the scientist, so maybe you want to add to that, but the length of time it takes to approve these processes, by the time that sort of these reports come out, we do need to bear in mind that the science has developed and that some of the impacts that the IPCC, is foreseeing might have already advanced way beyond sort of what we are then seeing at that point in time. Nonetheless, the consensus-based approach does also mean, and the fact that they review, these thousands of papers does sort of give that much strength to those arguments, that it makes sense to rely on them, nonetheless sort of pointing out that science will have also advanced beyond what they can tell us. I don't know if you want to add to that point.
So just to say to that, I do think that with most cases, your best case scenario is when you can rely on the IPCC, and that is for the majority of cases when you can, because it is seen as a consensus document. And it's important to know that attribution science is in the IPCC. There is a wide range of attribution science from all over the world that is included in the IPCC. Even though it's a fast-growing science, the field of climate attribution science has really only been around about 20 years, but it's developed very quickly in that time, and it's very robust. And if you actually look at the way the IPCC talks specifically about event attribution, and again, there's different types of attribution science we could get into the details of, but specifically event attribution, it's very strong the way that it's talked about within that. And then to the point that was being made here is that the IPCC is a process that's about every 7 years you get a new report. What they're doing is they're summarizing existing literature. So, and literature can take a couple of years, best case scenario, a year, sometimes a couple years to be published. So there's times when, as amazing as the IPCC is, you can have stuff that's already a decade old. That's coming into your newest report, and then you're relying on that report for almost another decade, right? So there's a really interesting balance there, which again, with the mitigation cases, most of them can rely on kind of that, it's a climate science case, and it can rely on that kind of alone, but it gets into making sure that we understand other dynamics as we get into other cases.
Great, so we just had the question about Climate Impact and Response Fund and also the ecocide question. I know we have a question online and we have a question on the floor, and just a reminder, we have about 15 minutes left, so maybe we'll do the Climate Impact and Response Fund and the ecocide questions quickly, and then move to on the floor and then in line.
I can respond to the ecocide question. So for those that aren't familiar, there are also ongoing efforts of including the crime of ecocide into the Rome Statute, so that the statute of the International Criminal Court. That was similarly to the ICJ advisory opinion, was also civil society movement that started that process, which I think, just to underline, kind of shows the strength of civil society in also pushing for sort of developments of this size. And so this was an effort of civil society to have, to start sort of recognition of a crime of ecocide. They had a panel of experts that drafted a definition. Again, and I think what's really interesting about this is it's not meant to be it was never meant to be the final kind of definition. It was just a working draft to start the conversation, to start the discussion amongst sort of practitioners, academics, amongst governments, and kind of take that forward. And so we now have a number of states that are in support of having an inclusion. I believe there was some talks of having that tabled at this year's Conference of the Parties. I'm not sure that has happened, but I know it's also ongoing at the moment, or it's wrapping up tomorrow, or at some point this week, the conference. And we're seeing sort of similar states, state actors in support of that we're also seeing in support of these advisory opinions. And I think what's quite remarkable about this is that it has sort of started a large societal discussion, about sort of moving beyond human-centered harms to also nature-centered harms, and how we understand, and how maybe mostly also countries and actors in the global north understand rights of nature. So I think that's sort of one byproduct of this process. I also think, to your point, another byproduct of that process is that people are starting to think about individual criminal liability, and I think that really does something to people that might be in positions of power, that might be in positions where their acts or their failures to act might amount to something that we would understand as ecocide. And so I think it was interesting. I was actually on a panel yesterday with a couple of people that are involved in this campaign, and one of their campaigners at the end just shared something that she had recently spoken to a CEO about, who said, actually, this gives me a lot of leverage because it then allows me to say, hey, I'm not going to be individually responsible for the company's, the board's failure to comply with certain provisions, to take more stringent action. And so actually kind of sharing a positive view from a business actor who said this also helps me in pushing for more ambition on environmental protection.
I'll just come in quickly on the Climate Impact and Response Fund. I don't think, or at least to the best of my knowledge, that it has been renamed yet. But I think that is a push from the US quite particularly, and I think it's quite transparently a liability issue. And this we saw last year when the fund was established, that the EU was also trying to make it basically an insurance fund, and sort of privatize the approach and use the Global Shield initiative in order to provide that financing. But that brings a whole host of problems, not least to do with the fact that they didn't clarify who would have access to that funding and how an insurance frame would work for loss and damage. So I think there's a lot of fear from the US side that if they put money into a sort of loss and damage framed fund, that it will just open the door for sort of a permanent liability given their historical emissions. We'll do the floor and then the online question, and we'll take them back to back.
Well, let's take the online first,
sure.
because I want to give back the mobile phone to our support. It's from Jelena, University of Cambridge. There has been a recent trend in bringing cases before English courts against English parent companies for actions of their subsidiaries abroad. She cites Okpabi, Vedanta, BHP. To what extent do you think we should welcome a greater involvement of English courts and courts of other Western states, as opposed to prioritizing local courts tackling such cases themselves?
Thank you so much. Can we take the floor question as well so we can answer them back to back?
Yeah, hello. I have a background, board member at the UN Decade on Ecosystem Restoration, and also Foundation's board member, World Economic Forum. Currently working on research around multi-species justice. I'm wondering, maybe building on the rights of nature and the ecocide question, where have you seen cases where should there have been maybe not an arbitration, but a mediation mechanism, that the rights of nature in ecocide law or principles of that nature would have helped tangibly? Where would it have helped? Where would it have furthered a case? Could have avoided litigation and instead gone into a mediation route? So yeah, just generally interested in in that perspective of cases you've dealt with where a species may be being represented or having a mechanism for another species represented would have furthered a cause, a case, a scenario?
Thanks so much.
I think that this discussion about the rights of nature, which, as you know, probably is much debated since 1970s, and that in reality has been through a certain evolution in the last years, because even though we have in some countries like Latin America's examples of this legislation in terms of rights of nature in constitutions or in laws in Bolivia, Ecuador, and others. In Europe, it's seen like, oh yeah, those kind of countries can do, but we can't. But actually, it's not true, because it's just how you see this kind of, it's not always about the personification of nature, and so also the same thing goes for the eco side. Is a different kind of approach that you are going to take. For example, if we see in Europe, we have the Directive 2004/35, which is environmental liability. And is really environmental liability. It's not indirect environmental liability like it was before. So in a way, we are really talking about this ecological damage. We are talking about what in France became the ecological prejudice. And in some countries, this is going through. In Italy, for example, you can see from my accent, I'm Italian, we have eco crimes. In France, they tried to do the eco side. Unfortunately, they didn't succeed, because now is not a crime, but it's a delict of ecocide. So it's not really that interesting from our perspective. But the problem is that when you're dealing with criminal law, you have to arrive to a certain degree of precision, which at this point, even with the report from Philippe Sands, Giorgio Meta, we understand that it's quite difficult, because we are talking about something that is international. We take into consideration many different things. So at this point, for me, it's an open debate, and it would be a great evolution if we arrive there. As I said, in the toolbox, we are also considering criminal side of corporate climate litigation. On the other side, there is so many avenues that we should just try to understand every legal system, what is on path. And to go back to the other question, the one on the possible transnational kind of cases, like in Vedanta, this is something that is actually happening in many parts of the world. Again, in France, for example, there is, the Vigilance Law of 2017, which in a way brings us really there, bring us to understand what the subsidiaries have done on the other side of the world. And so this is the same idea that we are trying to push at the European Union level with this new Corporate Sustainability Due Diligence Directive. We don't know if it's going to be at the level that we hoped, but the idea is to go in that direction, try and have always more responsibilities for those entities, even though they are trying to delocalize their activity, then trying to keep doing the same job that they are not doing in their home, but in another continent. So I think all these are really excellent kind of potential evolution and avenues. And so we are going to see, because it's also a political problem, as you can imagine.
Thanks so much. Did anyone else want to come in on the subsidiary question from online? Okay. Are there any final short questions? Then we'll do a quick round of just final remarks from the panel. Okay, great. We'll go to final remark. Oh, did you have a question?
Well, there was one question, a third one, which we had from our active participants from outside. And if I remember well, it was like whether the polluter pays principle can actually serve as a defense for governments.
As a defense for government, the polluter pays principle. Yeah, I mean, this is one other thing that has been debated in the last years. I think that in this moment there is a sort of trend of trying to de-responsibilize the governments or even the companies that are doing the same, saying, okay, we push, instead of making pay the one that's polluting, we have to understand who is polluting. So might be the consumer. The consumer buying a product is part of this chain. And so this is one of the big topics on climate litigation, which is, are you the victims of this kind of pollution, or you are the author of the pollution because, for example, you are using, I don't know, plastic bottles, you are using a car, So, yeah, I believe that these kind of arguments are really interesting, but that's why it's really interesting also to discuss about that. I don't know, before we were talking about science. In a way, in this moment, with science, law has to discuss a lot because there are many legal arguments that has to take into consideration what is hard science and what is the interpretation we give of this. For make a couple of examples, you know, the drop in the ocean argument, the one that was made also during the Urgenda case, which is quite clever. Like the Dutch government was saying, oh, so we are just contributing to a small amount, it's like a drop in the ocean. Why we should be held accountable for that and reducing our emissions? And actually, for what I know, no courts in the world accepted this kind of arguments. There is also the new one, the substitute argument, which is basically the one that is going to be brought also in the before the Court of Appeal by Milio Difensi, by Shell against Milio Difensi, saying, okay, we are forced to reduce our emissions because he's executive in the meantime before the second degree. But what's the problem? I mean, in this moment, there will be somebody else. If we stop to pollute, if we stop to do to create this kind of emission, there will be somebody else that is going to substitute this sort of area that we are living. So, in a way, these are all very clever legal arguments that are brought by companies, by states, sometimes when they have to try and discharge their responsibilities. We have to try and deal with that, take into consideration what is the reality of this, what is the science behind that, and knowing what is coming up in this moment, knowing that we have 6 years before 2030, probably not a great idea to listen to them.
Definitely. Thank you, Ivano. I'm just conscious of time, so I'll just move to very final remarks. And given that it's late, it's the 11th of December, we're all tired, I want us to close up by just a thing that is giving us hope in our different areas of practice. And I'll come to Jen first, then to Maria, and down the panel.
Well, what gives us hope is that we're here after the outcomes of the GST. We're still here at almost 8 p.m. and working together for different interdisciplinary approaches to the solutions, and that most of them are already there. It's the fact that we need to scale up different changes in our society and having all these approaches out there in the table, and looking forward to this new results of the advisory opinions, and how can we leverage this to build a case that time is running out for real now this time, and the science is clear that we need to reach peak emissions, and we're still not there yet in 2025. So we have one more year of work to do, and we're looking forward to see how this multi-stakeholder approaches can achieve this.
Thanks so much, Jen. We'll go to Maria and then Nigel for their comments online, if we can keep brief. Maria?
Hi again. Thanks so much for all your comments during the panel. Thanks so much for all the questions that also appeared during the event. It's very important that the discussion keeps on continuing from beyond this event, really, because we need all of the parties to be involved in resolving those issues. But at the same time, I've been really thinking about three main themes that I would like to take away from this event, especially about the seeing of the bottlenecks for the Global South in different cases, knowing their complex dynamics, and the dialogue between the science and the ancestral indigenous knowledge, and carrying out actions that contribute to the improvement of the living conditions of the communities and placing the nature at the center of the discussion. I guess it's very important to have those three components in mind when we are thinking about taking all those issues that have been talked about during the event to the ground, to the communities, to Global South as well, since I'm representing here the Chilean indigenous communities as such. So I'm very thankful for all your contributions, and
thank you, Maria.
I hope we're gonna continue on working on that.
Thank you so much. Yeah, thank you. Nigel?
40 seconds. I wish I was there to continue the conversation. The questions asked demand long answers, and I haven't got time for them, and you don't have time either. Could I just touch on one small point, and that's ecocide that was mentioned. It seems to me that now there is at least a legal definition of ecocide, which was completed in 2021. It may be that that's just one side of a multi-sided coin. And as we deal with the climate emergency, what may arise is the creation of a human right to a safe environment. And on the other side of that coin is the creation of a crime spread around the world to deal with those who destroy our environment. Thank you very much.
Thank you so much, Nigel. Thank you. Delta?
I'd say climate litigation has the potential to create conditions for accountability, and that gives me energy.
Thanks, Delta. Leah?
I'm going to join Jen and say community. We had a similar question yesterday, and it's I agree. Thank you all for saying this late, and it's nice to see all of these different people doing great work from different angles, and hopefully doing something a little more ambitious than what we're seeing at the moment.
Thank you. Ivano?
Just thank you very much, everyone, to be with us until so late. And please join us from the Global Toolbox on Corporate Climate Litigation. Thank you very much.
Thank you so much. Thank you, everyone. Have a lovely evening.
Can we get a group photo?
Yeah, your family photo.